South Dakota has one of the least regulated breaking lease frameworks in the country, consistent with the state's overall minimalist approach to landlord-tenant regulation. The governing law is found in South Dakota Codified Laws, Title 43, Chapter 32, which covers landlord and tenant relations, along with general contract principles. If you're a landlord or tenant in South Dakota, the limited statutory framework means the lease agreement itself is your most important document when a tenant needs to leave early. Let's start with the landlord's duty to mitigate damages. South Dakota recognizes the landlord's duty to mitigate through both statutory provisions and common law principles. Under South Dakota Codified Laws, Section 43 for 32 Ad 15.1, when a tenant breaks a lease and vacates, the landlord has a duty to make reasonable efforts to re-rent the unit. The landlord cannot simply leave the unit empty and hold the departing tenant liable for the full remaining rent. This statutory mitigation duty is straightforward. The landlord must take reasonable steps to find a replacement tenant. What constitutes reasonable depends on the circumstances, the local market conditions, the property's condition, and the landlord's typical practices for filling vacancies. The landlord must advertise, show the unit, and accept qualified applicants. The landlord is not required to lower the rent below market rate or accept an applicant who doesn't meet legitimate screening criteria. If the landlord re-rents the unit, the departing tenant's liability is limited to rent during the vacancy period, plus reasonable re-rental costs. If the landlord fails to make reasonable efforts, the departing tenant's liability is reduced by the amount of rent the landlord could have collected through reasonable mitigation. Early termination clauses are generally enforceable in South Dakota. The state does not have a specific statute capping early termination fees or restricting how leases handle early departure. South Dakota's contract law principles govern, and the state generally enforces reasonable contractual provisions between private parties. A clause requiring 30 to 60 days notice and a fee of 1 to 2 months rent is typical and enforceable. South Dakota courts will enforce early termination fees that represent a reasonable pre-estimate of the landlord's anticipated damages. A fee that is grossly disproportionate to actual damages, a punitive amount designed to prevent early departure rather than compensate for loss, could potentially be challenged as an unenforceable penalty. But South Dakota's overall legal culture gives significant deference to negotiated contract terms. Military members have the right to break a lease under the Federal Service Members Civil Relief Act. Active duty service members with qualifying orders can terminate by providing written notice and a copy of the orders. The lease terminates 30 days after the next rent due date. No early termination fee or penalty applies. South Dakota's military population is centered around Ellsworth Air Force Base near Rapid City and the South Dakota National Guard. Ellsworth AFB generates regular SCRA lease terminations in the Rapid City area. Landlords near Ellsworth should have a standard process for handling military lease breaks: verify the orders, accept the notice, calculate the termination date, and process the deposit return within the statutory timeframe. South Dakota does not have a specific state statute providing enhanced lease-breaking protections for victims of domestic violence. Unlike states that have enacted dedicated provisions allowing domestic violence victims to terminate a lease early with documentation, such as a protective order or police report, South Dakota has not enacted such a provision. Domestic violence victims who need to break a lease in South Dakota must rely on general contract principles, negotiate directly with the landlord, or seek assistance through advocacy organizations like the South Dakota Coalition Ending Domestic and Sexual Violence. This is a gap in South Dakota's framework, and one that landlords can address voluntarily, including a domestic violence early termination clause in your lease. Allowing termination with 30 days' notice and a copy of a protection order is a best practice that protects vulnerable tenants and reduces the risk of a tenant fleeing without notice because they felt they had no legal option. Tenants in South Dakota may break a lease if the landlord fails to maintain habitable conditions. Under South Dakota Codified Laws, Section 4332(8), the landlord has a duty to maintain the premises in a condition fit for human habitation and to make repairs necessary to keep the property in a reasonable state of repair. If the landlord fails to address serious habitability issues after receiving proper notice, the tenant has remedies that can include lease termination. Under Section 43-32-9, the tenant must provide written notice of the deficiency. The landlord then has a reasonable period to make the repair, typically 14 days for non-emergency conditions. If the landlord fails to repair within the statutory period, the tenant can terminate the lease by providing written notice and vacating. The tenant is not liable for rent beyond the termination date if the termination was based on the landlord's failure to maintain habitable conditions. For emergency conditions that pose an immediate threat to health or safety, such as a failed heating system in winter or a sewage backup, the timeline for the landlord's response is shorter. The tenant should provide notice and allow a reasonable but expedited period for emergency repairs before terminating. South Dakota also recognizes constructive eviction as grounds for lease termination. If the landlord's failure to maintain the property or the landlord's affirmative actions, shutting off utilities, failing to address dangerous conditions, changing locks, make the unit uninhabitable, the tenant can treat the lease as terminated. The tenant must vacate within a reasonable time to establish constructive eviction. South Dakota has specific provisions regarding abandonment. Under Section 43-32-15.1, if a tenant abandons the property, the landlord can retake possession and re-rent the unit. The statute defines abandonment as the tenant's absence from the premises for a continuous period, combined with non-payment of rent and removal of personal belongings. The landlord should document evidence of abandonment before re-entering. Unpaid rent, absence, removed belongings, disconnected services. The departing tenant remains liable for damages, but subject to the landlord's mitigation duty. The landlord cannot simply declare abandonment and pursue the full remaining lease amount without re-renting or attempting to re-rent. South Dakota has a relatively fast eviction process, which affects breaking lease dynamics. The state allows just 3 days' notice for non-payment of rent before the landlord can begin eviction proceedings. This fast timeline means landlords can quickly regain possession when a tenant stops paying rent as part of breaking the lease, reducing the overall vacancy exposure compared to states with longer notice and eviction timelines. From a practical standpoint, South Dakota's rental market is small and concentrated in a few population centers, and the local market directly affects how breaking lease situations play out. Sioux Falls is the state's largest and most active rental market. The economy is driven by healthcare, Sanford Health and Avera Health, financial services, agribusiness, and manufacturing. Sioux Falls has experienced steady population growth, and the rental market has tightened. When a tenant breaks a lease in Sioux Falls, the landlord can typically re-rent within a reasonable time frame, perhaps 2 to 4 weeks for a well-maintained unit in a desirable location. The departing tenant's liability is usually limited to a month or two of vacancy in most market conditions. Rapid City, the state's second-largest city, has a market influenced by tourism, healthcare, and Ellsworth Air Force Base. Military lease terminations from Ellsworth are a regular occurrence. Rapid City's overall market is moderate. Re-rental times depend on the season. Summer, when tourism peaks and people are more likely to relocate, is easier for filling vacancies. Winter breaks in Rapid City's climate may take longer to fill. Brookings, home to South Dakota State University, and Vermilion, home to the University of South Dakota, have student-driven markets with strong seasonal patterns. A lease break timed to the academic calendar, spring or summer, can often be filled quickly with incoming students. A mid-semester break is harder. Aberdeen, Watertown, Mitchell, Pierre, and Huron have smaller markets with more limited applicant pools. Re-rental in these communities may take longer, particularly in the winter months. Landlords in smaller South Dakota communities should set realistic expectations about re-rental timelines and structure their leases accordingly. The Bakken Oil region, centered around the western part of the state near the North Dakota border, has experienced boom and bust rental dynamics driven by energy prices. During active drilling periods, units can be filled immediately. During downturns, vacancies persist. Landlords in the oil-influenced areas should understand these cycles when evaluating breaking lease liability. One best practice for South Dakota landlords: include a clear early termination clause in your lease. Given the state's limited statutory framework, the lease is your primary governing document for handling early departures. Specify the notice period, 30 to 60 days, the fee amount, how the security deposit will be handled, and the condition the unit must be left in. A well-drafted clause eliminates ambiguity and gives both parties a clear process. Another best practice: document your mitigation efforts meticulously whenever a tenant breaks a lease. South Dakota's statutory mitigation duty under Section 4332.15.1 means you must demonstrate reasonable re-rental efforts. Keep records of listing dates, advertising platforms, inquiry counts, showing dates, and when you accepted a replacement tenant. Include costs for cleaning, repairs, and advertising. This documentation establishes the departing tenant's actual liability and proves you fulfilled your duty. A third best practice: consider voluntarily including a domestic violence early termination provision in your lease, even though South Dakota doesn't require it. A clause allowing termination with 30 days' notice and a copy of a protection order costs you nothing when the situation doesn't arise, and protects vulnerable tenants when it does. It also reduces the risk of a tenant fleeing without notice, which creates a worse outcome for everyone. South Dakota requires landlords to return the security deposit within 2 weeks of the tenant vacating and providing a forwarding address, if there are no deductions. If the landlord intends to make deductions, the timeline extends to 45 days, and the landlord must provide an itemized statement. The deposit is limited to 1 month's rent unless the landlord can demonstrate special conditions justifying a larger amount. These rules apply whether the departure is a normal move-out or a broken lease. For the complete guide to South Dakota breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.